Yes, yes. It was perfect. Italian, exactly. I can hear you. Yes.
Shall we start, Ihsan, now?
Yes, please.
Okay. So, good evening. Welcome to everybody who's with us for this afternoon, this afternoon or this evening, depending on the place where you are, or maybe this morning. So this webinar is dealing with the very important and timely issue regarding the legal obligations of the states and private entities, companies, under the international law of the sea, with regard to the transfer of weapons, arms, and energy to a state that is committing war crimes, crimes against humanity, and plausibly crime of genocide. This issue is under probably studied and under discussed at the international level, because normally when we talk about the law of the sea, we discuss territorial areas within the sea, and the issue of the law of the sea and the human rights in the wider sense of the term, including international humanitarian law and international criminal law, is still needs lots of discussion. But it's good to start by this. Let me start by, after welcoming everybody, to say a few words in Arabic for our Arabic-speaking audience, and then we'll proceed in English. This webinar will be conducted entirely in English, with interpretation into simultaneous interpretation into Arabic. So نتكلم بعض الكلمات باللغة العربية للترحيب طبعا بالمتواجدين معنا الناطقين باللغة العربية. هاي ورشة العمل أو حلقة النقاش راح تركز على موضوع واجبات الدول والشركات والمؤسسات الخاصة والسفن حول موضوع نقل الأسلحة والطاقة بما فيها الغاز والبترول للدول التي ترتكب جرائم حرب وجرائم إبادة جماعية، بما فيها جريمة وخاصة جريمة الإبادة الجماعية كما يحدث حاليا في قطاع غزة. طبعا هاي ورشة العمل أو هذا الويبينار راح يتيح لكم مجال انكم تسألوا باللغة العربية، والمتواجدين معنا من خلال اليوتيوب راح يكون العرض فقط باللغة الإنجليزية، ولكن راح تتوفر الترجمة الكاملة باللغة العربية في وقت لاحق. وطبعا بإمكانكم تطرحوا الأسئلة بعد انتهاء العروض باللغة العربية، سواء من ناحية شفوية أو من خلال الكتابة على الشات. بدي أكد كمان على أنه متوفر الترجمة باللغة العربية من خلال الضغط في أسفل الشاشة على إشارة الكرة الأرضية، بإمكانكم تتكوا عليها ففي مكتوب interpretation أو ترجمة، ومن خلالها بإمكانكم تختاروا اللغة واختاروا اللغة العربية، وبالتالي راح تسمعوا الترجمة باللغة العربية. طبعا now I will be back. I'm back to English to again welcome you all, especially our distinguished speakers, experts in international law of the sea, international human rights law, human rights and business. And as I mentioned, this issue on the link between the law of the sea and the human rights is a newly discussed topic. I know ASCOMARE is focusing on this issue at the moment, but I think it's important to kick off or start the discussion on the issue of the law of the sea and human rights. Let me first also introduce myself. My name is Mu'taz Qafishe. I am professor of international law at Hebron University in Palestine, and I'm speaking now from Jerusalem. And I'm also the head of the board of trustees of the Law of Palestine. This webinar is organized by Law of Palestine, Law for Palestine organization, in cooperation with the ASCOMARE organization that focuses on the study of the law of the sea, and the independent Palestinian Independent Commission for human rights. Just also to introduce myself, that I'm mainly specialist in international law, and I recently, a few years ago, started to write about the law of the sea. So let me start by saying a few words about the links between the law of the sea and human rights, specifically when it relates to the case of Palestine and the genocide that taking place at this moment as we speak in the Gaza Strip. Palestine acceded to the United Nations Convention on the Law of the Sea, UNCLOS, in 2014, which entered into force in 2015, and whereby Palestine demarcated and claimed its maritime zones overlooking the Gaza Strip. For those who don't know, the Gaza Strip is overlooking about 40 kilometers on the Mediterranean, and that gives Palestine, of course, at least 12 nautical miles on the coast of Gaza, in addition to up to 200 nautical miles in the exclusive economic zone for Palestine, which give Palestine exclusive sovereignty, I would say, of sovereign rights on the resources that exist in the exclusive economic zone. And this is not only the story. The story is that this convention, the UNCLOS, or the United Nations Convention on the Law of the Sea, establishes obligations on all member states in this convention to implement the convention in light of the general rules of international law, including the international humanitarian law, international human rights law, the law of genocide, the law of energy, the law of weapons transfer, etc. And in particular, all states and ships that fly any flag of any member state of the UN clause is under obligation, as Brandria will discuss in detail, under an obligation, erga omnes obligation, to prevent the arm transfer to Israel as a state that commits war crimes and crimes against humanity, and as the ICJ, the International Court of Justice, decided in the South Africa versus Israel, a plausible case of genocide that is taking place in Gaza right now. So this seminar, or this webinar, will discuss this issue, in addition to the obligations of all riparian states in which ships, vessels, passes through these territorial coastal zones, where these states have an obligation under international law of the sea to monitor these ships that carry weapons and energy to a state that is committing war crimes and crimes against humanity. Of course, this also established obligations not only on states and governments, but also on companies and private entities that ship the weapons to the state of Israel. And this issue, the erga omnes obligations and the jus cogens obligations, which means the peremptory rules of international law that establish obligations on all states, brings to the fore also the issue of the advisory opinion that decided by the ICJ, the International Court of Justice, in July last year, whereby the court ordered Israel to end its occupation to the territory of Palestine, not only Gaza Strip, but also the West Bank, including East Jerusalem, and established obligations on all states to end that occupation. And as we know, the General Assembly decided in September last year that this occupation, based on the ICJ decision, should end within 1 year. That means in September this year, after 4 or 5 months, the world and the court and the international law order in general will be at the moment of truth. How, and this is a big question that might be discussed by the speakers this evening, what states ought to do, what are their obligations in order to not only prevent and put embargo on the transfer of weapons and energy to Israel, but also, which is a bigger question, to end the Israeli occupation to Palestine. I don't want to take more time. I will start the webinar by giving the floor to our first speaker. Our first speaker is Dr. Irene Pietropaoli. Irene is a senior fellow in business and human rights at the British Institute of International and Comparative Law, and she's expert in international law and the director of Human Rights and Human Rights Due Diligence Forum, and conducts in-depth research on issues relating to corporate responsibility with regard to human rights in general and the law of environment. Irene, you have the floor. You can speak for 10 minutes, and then we'll move to the second speaker. So please go ahead.
Thank you for the introduction and the background. As other experts will focus on the specific aspect of the law of the sea, I'm actually going to cover some point related to the implication of the ICJ preliminary measures, orders, and the advisory opinion that you just mentioned. So I will cover 3 points. One is the implication of the ICJ provisional measure on genocide related to state parties and corporations. Second, the implication of the advisory opinion on the unlawfulness of the occupation. And third, what are actually the obligation and the accountability of corporations that are currently selling and transferring and shipping arms and weapons to Israel. So in relation to the first point, so the implication of the provisional measures on genocide, the obligation of third states to comply with the ICJ order, they flow directly from the Genocide Convention. Article 1 of the conventions requires states to undertake to prevent and to punish genocide. So it's an obligation, a negative obligation not to commit or be complicit in genocide, and a positive obligation to prevent and to punish genocide. In relation to the obligation not to be complicit in the commission of genocide, the ICJ had already clarified in the Bosnia versus Serbia case that this obligation to refrain from being complicit through aid or assistance start at the moment that the states becomes aware of the existence of a serious risk that the genocide may be committed. So it doesn't need to be already found genocide, but already at the moment of be aware of the risk. So the order that was issued by the ICJ finding like a real imminent risk that a prejudice will be caused to the rights found out by the court to be plausible. So in short, that there is an imminent risk of genocide means that states are aware of this risk. And so here, third states must consider that their military or other assistance to Israel military operation put them at risk of being complicit in genocide under the Genocide Convention. But also corporation and their manager, directors, other leaders of a company could also be held liable for the commission of act of genocide and complicit, as well as war crimes and crimes against humanity. This is because Article 6 of the Genocide Convention specified that persons must be held liable for genocidal act. So this could include also individual businessmen or corporate leaders as natural person. As you mentioned, the prohibition to commit genocide is a ius cogens norm from which no party, including corporation, can derogate. And in addition, international humanitarian law binds states and non-state actors, including business, as well as individual business leader, whose activities are linked to international crime during an armed conflict. This notion of this concept of corporate complicity implies that corporation may be aiding or abetting genocidal act perpetrated by others, so in this case by the state of Israel. So a corporation or an individual business person who knowingly assist the State of Israel in violating customary international law, including the prohibition of committing genocide, may be complicit in such violation. In this case, it's not required that this accomplice, the corporate accomplice, decide that the principal offense is committed, nor that the actor need to intend the result. So it's enough that the corporation of his agent knew of the likely effect of their assistant, and that such support as a substantial effect on the commission of genocide. So companies investing or partnering with the Israeli government or also with Israeli-owned enterprises face really a salient risk of aiding and abetting, facilitating, or contributing to genocide. So in particular, arms, weapon, ammunition, vehicle, other military supplies that are essential to the activity of the Israeli Air Force, ground force, Navy, that they make an essential contribution to the violation of international humanitarian law and genocidal act against the Palestinians. Then there is also the obligation to prevent genocide. So this obligation and the duties start, as the ICJ had clarified in Bosnia versus Serbia, at the instant that the state learn or should have learned of the existence of a serious risk the genocide will be committed. So it is necessary that the situation amounts to a serious risk and that the states know or should have known about that situation. So again, the CJ finding of plausible rights and imminent risk constitute this knowledge. And so it triggers third state legal obligation under the Genocide Convention to prevent genocide. So this obligation to prevent is an obligation of conduct, not of result. So meaning that it is about whether the states, is not about whether the states achieve the results of preventing genocide, but whether it took all necessary measures that are in power to preventing genocide. So this is not a passive obligation, but actually implies the notion of due diligence. So it's an assessment based on fact. And the ICJ has clarified that it is related to the state capacity to influence the action of the person likely to commit genocide. So this capacity of influence depends, as the ICJ has clarified, on, for example, geographical distance of the states, strengths of political links, and other links. So this means that while all third states have the duty to prevent genocide, this responsibility is heightened for states that have this capacity to influence. So in this case, for example, the US, the UK, Germany, they have like the strongest political and economic link with Israel, have this enhanced responsibility to prevent genocide. Then second point is actually also on the implication of the other advisory opinion on non-assistance in the unlawful occupation, because as you mentioned, as the ICJ conclude the Israel prolonged occupation is unlawful, it also reaffirmed that states are under the obligation not to recognize this legal situation. So the principle of non-assistance is an expression of customary international law when dealing with serious breaches of peremptory norms. Here is about the violation of the Palestinian right to self-determination. So arms and related supply that assist Israel military occupation or enable the commission of violation in the occupied territory constitute also aid or assistance in maintaining an unlawful situation. So states violate international law if they knowingly supply or facilitate the supply of weapons or other commodities that are essential to Israel's illegal occupation. So in practical terms, this means that any states allowing arms shipment by sea to Israel, for example, permitting a weapons carrying vessel to depart his port or pass through his water must ensure that it is not aiding or abetting the illegal occupation or the commission or war crimes. In October last year, for example, the Irish government announced plans to impose trade sanction on Israel that following an advice from its Attorney General, and this move aligns to Israel trade policy in response to this ruling of the ICJ that country must avoid economic dealing with Israel concerning the occupied territories. And so the last point is about the obligation on corporation, because here thinking also about common Article 1 of the Geneva Convention that requires states party to refrain from transferring weapons if there is an expectation that this weapon could be used to violate the convention. There are also obligations the state have under the UN Arms Trade Treaty. So state have obligation to deny arm export if they know that they will be used in committing international crimes. EU member states are further bound by the EU common position arm exports, but independently from home state regulation, companies that sell weapons, arms, ammunition, technology, also oil and fuel, also artificial intelligence, other military supply, anything that is assisting the government of Israel to commit violation of international humanitarian law, international criminal law, they have separate responsibility independent from the home states. There are international standards like the UN Guiding Principle on Business Human Rights that articulate this expectation that business respect human rights. Principle 23 of this guiding principle specify that there is a heightened human rights due diligence by both states and corporations in conflict-affected areas. And so what companies need to do is to conduct human rights due diligence, have an understanding not only on the impact on human rights, but also the impact on conflict. And this is not limited to the war in Gaza, but inevitably it needs to expand to understand the business impact and contribution to the wider conflict and occupations. And then companies have to understand that when they lack the ability to have leverage to prevent or mitigate adverse impact, like is in the case of assisting the government of Israel, then they need to end any existing relationship. Otherwise, they risk to be held complicit in a serious violation of human rights. This risk are particularly salient for companies that are investing and partnering with state-owned enterprises, for example, firms that provide arms and weapons. But despite that, still, and I finish here, but still we know that, of course, there are still so a sale and transfer of weapons has persisted despite repeated calls, including from the UN Human Rights Council. There are dozens of companies, especially from the US and Germany, but also the UK, that sell and transfer arms, weapon, ammunition, oil, and fuels. And there are currently a number of ongoing cases at the domestic level challenging this action. For example, in the UK, there is a case filed in 2023 in the UK court challenging the government decision to continue arms sales to Israel, which is the hearing is actually expected next month. There is a case in the Netherlands where the Court of Appeal ruled that the Netherlands must cease exporting F-35 fighter jet parts to Israel. And in Denmark, there are cases as well in a number of other European countries and in Canada, for example. And with this, I'll conclude. And of course, if there are any other questions later on, we can address specific issue in more details. Thank you.
Thank you, Irene, by setting the stage for the discussion in this webinar. You detailed the norms, standards that states and companies should comply with in order to prevent and not to be complicit in committing genocide. Also, you mentioned some cases in the UK and Netherlands and other places where these norms can be potentially respected and implemented. But particularly, I think here we need to look at the law of the sea and how the law of the sea can, I would say, intervene in preventing companies, because most of the armed and oil transfer globally, not only to Israel but also at the global level, is shipped by ships through the oceans and seas. So here we look at the issue of the law of the sea and how states, companies, ships can be responsible. What are their obligations under the law of the sea, and more importantly, how these obligations may be enforced. So in this topic, we'll have Mr. Brendria Luigi. He's our friend, or normally call him Leo, which is easier than Brendria. Brendria is the director of ASCOMARE, this institute that is focusing on the study of the law of the sea. And Brendria participated with a team of researchers from his organization by providing legal opinion on the obligations of states under the law of the sea. I read most of this study, and it's very, very interesting and innovative. And we look forward to listen to your findings in that study, Brendria. You have the floor. Please go ahead.
Thank you very much, Professor Motez, for the floor and for these timely discussions. I will try indeed to stick with the clock and to give you a short overview of the key findings of this and the legal considerations emerging in particular from this legal opinion. This is a legal opinion that was commissioned by the BDS National Committee and was coordinated by ASCOMARE. If I'm not mistaken, this was published. It was on the 11th of March, so in any case, was very recent. While ASCOMARE oversaw the coordination of the project, the opinion itself was drafted by a team of 8 legal experts in different areas of the law of the sea. So expert in human rights, in navigational rights, in due diligence, and supported by additional research staff. So it was an important collective work, and I also take the opportunity to thank all the people who took part in this project on top of their very busy agenda. So the process involved, let's say, intensive research, also collaborative drafting, of course, and internal discussions. I must say that in contrast, for instance, to similar legal initiatives in which I was involved in the past, I think with this opinion was marked by a high level of consensus among the contributing experts, which I think is something that speaks for itself. And lends, let's say, further weight also and coherence to the different findings and conclusions. We are talking about a document, a 49 pages document, which addresses in particular 2 core questions. The first questions concern the regime of innocent passage within the territorial sea. For those of you who are not familiar with this topic, the territorial sea is the breadth of sea which extends normally up to 12 nautical miles from the baselines, which is either a line, let's say, along the coastline, or in some cases a line across the sea, but still very close to the shore. And the innocent passage regime is innocent passage is a right which is recognized. It's a very old right which reflects customary international law. It's recognized to the vessels of all states which can traverse the territorial sea of another country under certain conditions. Now, specifically, let's say the first question examined whether coastal states possess not only the right, but also potentially the obligation to suspend the passage of a foreign ship navigating through its territorial sea, where in particular the vessel is transporting arms or other equipment intended for use in the commission of acts such as genocide, apartheid, or otherwise engaged, let's say, in conduct which are not compatible, which are against peremptory norms of international law, so jus cogens. Now, in short, what the expert group concluded is that there is indeed a right to suspend the passage. This right in particular is encapsulated into the conventions that Professor Motas was mentioning, which is the framework conventions governing the law of the sea, so UNCLOS. But is also the relevant provisions also reflect customary international law and therefore are applicable and binding on all states. There are in particular three circumstances where the right, where the coastal state has a right to suspend the passage of a foreign vessel. The first one is when there is a complicity in the threat or use of force. In this case, in violations, of the principles, the fundamental principles embodied into the UN Charter, including, for instance, the principles of territorial integrity and self-determination. Then we have circumstances, a possible suspension in the event of the exercise of criminal jurisdiction on board the vessel. Of course, the cases which are covered by UNCLOS are in a certain way limited in scope, because that was not the main objective of the conventions. This is also an article which is sort of inherited from the 1958 Geneva framework. But this is, of course, without prejudice to any kind of powers that the coastal state may have to enforce, to exercise criminal jurisdiction, for instance, to enforce international arrest warrants or in other cases covered by international law. And then we have the third case, which is probably the most important, that was examined in the context of the legal opinion. So the possibility to suspend the passage when there is the passage itself is in contrast is not consistent with the broader obligations of the states under international law. And this is included in particular in the chapeau of Article 19, paragraph 1 of UNCLOS. Why this is important? Because this is a sort of a legality text, is an umbrella provision, which indicates, of course, that if the passage is created tensions between other obligations which are binding on the coastal state, and this obligation in particular, we're talking about those stemming from peremptory norms of international law, but also the expert group examined those, for instance, encapsulated into the arms trade treaty, the genocide conventions, the apartheid convention. So in all these cases where we have a specific threshold, which is very high, there is not only the right of a coastal state to suspend the passage of foreign vessels, but also a duty. There is a legal duties which should be exercised by, should be discharged by the coastal state, and that could otherwise lead to responsibilities for in non-compliance with international law and the corresponding, of course, the responsibilities under the rules of state responsibility. Yeah? So this was a very important findings. As I mentioned before, these rules reflect customary international law. So even if UNCLOS is ratified now, I think we reached the 170 ratifications. So it's highly ratified, and many of the rules also are in line with the previous Geneva framework of 1958, but in any case, it's widely recognized the customary status of these provisions. The second aspect, which is also the second question, which is also very important, concern the role of the flag states. So we look at what happens in the waters of the coastal state while the vessels are traversing these waters, but what is the responsibility of the states of nationality of these vessels? Now, the second questions in particular concern the role and responsibility of state with respect to ensuring that vessels flying their flag comply with the obligations arising under the ATT, the Arms Trade Treaty, as well as peremptory norms of international law. The expert group in this case concluded that flag state bear, let's say, not only a general responsibility to effectively exercise jurisdiction and control, this is the language used into Article 94 of UNCLOS, over vessel registered in their territory, but they also have a due diligence, a specific due diligence obligation under both UNCLOS and customary international law. This obligation is an obligation to ensure, so an obligation of conduct, like the one mentioned by Irene, to ensure that such vessels act in compliance with the international obligation which are binding on the flag state itself. Now, this due diligence requirement is the result of a combined reading of Article 91 and 94 of UNCLOS, which is a finding in itself because, of course, it creates a direct link with the legal basis into the UNCLOS, resulting in the case of non-compliance with these specific obligations also into a breach, potential breach of the UNCLOS obligations. And this is an obligation for the flag state to take adequate measures to do the utmost to prevent violations of international law. There is quite an extensive case law on recent, but in any case extensive on due diligence and the law of the sea. So failure to fulfill these obligations may give rise to the international responsibility as well of the flag state. And even in this case, the expert group concluded that these rules reflect customary international law. So to conclude, we have a coastal state possessing not only a right, but also an obligation, a duty to prevent the passage and, where necessary, to take appropriate enforcement measures against the foreign vessel transiting in the territorial sea when this passage is inconsistent with the international legal obligations binding upon that state. And this is particularly the case where those obligations reflect jus cogens or when, let's say, where the state's inactions would give rise to an internationally wrongful act under the rules governing state responsibility. And then we have a flag state duty. This is, on the one hand, the right to exercise effective control of jurisdiction, but also a duty to ensure that vessels flying the flag of this state comply with the international obligations which are incumbent upon that flag state. This includes obligation under the ATT, the Genocide and Apartheid Convention, the UN Charter's principles, and other jus cogens norms. This duty, let's say, is rooted into the due diligence obligations, which require the state to take proactive action, so legislative, administrative, enforcement action to ensure compliance. Then I know that I'm aware we are running short on time, so I will stop here. But just for you to know that, of course, there are certain aspects which are not specifically covered by the legal opinions, but that are still connected, of course, with the reality on the grounds today, and they should be read against the backdrop of this reality. For instance, what happens when the vessels operated outside the territorial seas, so for instance, in the exclusive economic zones, what are the port state jurisdictions, the port state powers, when the vessels, for instance, enter into port, or to prevent the vessel entering into port. What is the regime of international straits? So there are a lot of different aspects, of course, which are connected with the finding and the conclusions of these legal opinions that, of course, will deserve also further discussions and examination. But thank you. It's all from my side, and I will be happy to answer any question later on.
Thank you, Brendri. I think what makes your study is interesting is that it raises so many questions that I think will open the floor for other research that I think very much needed, not only with regard to Palestine, but also at the global level. And in particular, the issue of the mechanisms, how states and companies can or who will monitor the obligations of states and companies to comply with these obligations. I think this is something that can be built on your study, and also maybe to apply the general rules of international law of the sea with regard to obligations of all states in the world to prevent crimes against humanity and war crimes, not only in the territorial waters but also in other zones, including the contentious zones, because this zone relates mainly to the security of states. But when it comes to war crimes and crimes against humanity against any state, it's a crime against every state as well. So would other states also have responsibility in the contentious zones in addition to their territorial waters? And probably we can discuss issues of their obligations in the exclusive economic zone as well as in the high seas, and probably the issue of the right of visit to invade vessels and ships can be extended to other crimes, not only the ordinary crimes but also crimes against humanity and war crimes. So let's move now to the issue of oil and gas. And of course, oil and gas during the time of war is also a weapon, and how the embargo and boycott for states who commit grave international crimes can be enforced. So Anna Sanchez, I hope that I pronounced the name correctly, who is the coordinator or global coordinator of a global energy embargo campaign for Palestine. She will address this issue, the issue of global energy embargo for Palestine, and how that campaign can be carried out and implemented by states and by companies. So Anna, please, you have the floor.
Thank you so much for having us here, for having me here today. The Global Energy Embargo for Palestine is a network of activists, of researchers, trade unionists that calls on states to impose a full energy embargo on Israel, to halt all energy imports and exports, and also to make sure that private corporations comply with their obligations under international law and human rights across all the energy value chains, right? Because like we've been talking about the importance of an arms embargo, and you might wonder why also an energy embargo, right? Because energy can be perceived as a more neutral form of trade, but I guess like I'm making no spoiler here in saying that there is no neutral form of trade. And in the case of energy, we can think that it may be something that sustains life. But in the case of Palestine, energy is sustaining Israel regime of settler colonialism, illegal occupation, apartheid, and genocide. And it is important to acknowledge how Israel is using energy as a tool of oppression. And I guess that was something quite clear and straightforward during the ongoing genocide, particularly in the Gaza Strip, where Israel announced a complete siege, including banning all access to energy. And not having energy, it doesn't only mean not having electricity at night, it means not being able to power hospital, to power desalination plants, to power sewage systems, in general, to power what sustains life. And these sort of acts of intentionally denying the right to energy has been described by organizations like Human Rights Watch as genocidal acts. But this is not only something specific to the Gaza Strip. Israel also uses energy as a tool of oppression in the West Bank by, for instance, denying systematically all the permits of Palestinians to being able to develop their own energy infrastructures, while at the same time they keep allowing all the expansion of the illegal settlement industry in occupied Palestine. They also use electricity cuts as a form of collective punishment. And last but not least, if we look at how the electricity grid is designed in Israel, we see that the settlements are directly connected to this grid. They are an integral part of it. That means that every single piece of energy that is powering this energy grid is powering the illegal occupation of Palestine. And as the previous speakers, Irene and Pierandrea, have beautifully described, that has consequences under international law, because all states, third states, have also legal responsibilities in order to stop rendering assistance to war crimes and crimes against humanity. And I guess that's already quite clear, but of course energy has also been used to power all the military vehicles, warplanes, to provide electricity to the artificial intelligence that is being used to surveil and kill Palestinians in the Gaza Strip. So I think it is clear why we need an energy embargo on Israel and why we need to stop this energy complicity with the ongoing genocide in Palestine. But who are the main suppliers of this energy? Because Israel is not able to sustain all this structure of violence, oppression, and discrimination on its own. Israel can cover some of its energy needs with natural gas mainly, which can cover approximately around 40% of the Israeli energy needs. But for the other remaining part, it relies on external sources of energy. And in here we have countries like Azerbaijan, Kazakhstan, Gabon, Nigeria, or Brazil, which are providing Israel with crude oil and also refined fuel. Then we have also countries like Russia, South Africa, and until recently Colombia, that are providing Israel with the coal that they need to be burned to then feed all the electricity grid and to cover its needs in terms of electricity. And then in terms of jet fuel, which is a kind of refined fuel that is used to cover all the military needs, we have the US as the main supplier. And on top of this use of energy as a tool of oppression, and this energy being used to fuel an ongoing genocide and sustaining an illegal occupation, we have to take into consideration that all these sources of energy that I mentioned are fossil fuels, meaning that are not only jeopardizing the life of Palestinians, but also the sustainability of our planet. These also have a massive impact in accelerating the current climate emergency that we are living in. And of course, all this energy, all these energy sources, they do not magically appear in Israel. They need to be transported somehow. And by being here today, I guess you are already guessing how all this energy is being shipped. And yes, it is by maritime transfers. Along with military equipment, we are seeing now how vessels, ports, and many other actors are being used to assist and be complicit on this ongoing genocide. As part of the Global Energy Embargo for Palestine network, we are part of the No Harbors for Genocide campaign, which is a campaign that tries to visualize precisely the crucial role that that ports play in this transport and distribution of energy, and also military supplies that are sustaining this genocide against the Palestinian people. And one of the things that we've learned over this last terrible and dark months is that we have a very powerful legal framework, as Irene and Pierandrea already explained. But this legal framework is not going to work on its own. And we need to mobilize popular pressure. We need to mobilize this pressure from below in order to apply this system of international law that we have, that is described, that we can see, and they have explained that we have regulations that the states can ban vessels with weapons, that they can ban all these logistics of genocide, but that's not happening. That's not happening because there is not political will for doing so. And this is why it is important to mobilize and to organize collectively collectively to stop all these shipments that are directly going to assist the ongoing genocide. So one of the things that we've been doing as part of the No Harbors for Genocide campaign, as I said, is trying to identify the actors that are involved, that are needed for this logistic support. And that are not only the vessels or the port. We need to think also about the operators, the companies that are helping to put all this in place. We need to think about insurance companies that are insuring the cargo that these vessels are carrying. And one important thing is that we need to be able to develop strategies that kind of are able to address the issue in a more holistic way, meaning that we cannot go boat by boat. I mean, we will do it if needed, and we have done that in the past. Like if we think about the example of the Spanish state, where I am based, and is the port of Algeciras at the south of Spain, which is the entrance of the Strait of Gibraltar, and highly complicit in allowing the transfer of energy and weapons to Israel. We've been really going boat after boat, but one thing that we've learned is that there are patterns. We have vessels that have been doing recurrent routes transporting weapons and energy. And in the past, we succeeded. We managed to have several vessels like Borkum carrying weapons, Overseas Santorini carrying jet fuel that did not dock in Spanish ports. And we will continue to do so because we have the moral and the legal obligation to keep doing so, to cut ties with this genocide. But what we want to achieve, what we want, the change that we want to see now is to have a ban on this list of vessels that are currently doing routes that are assisting the ongoing genocide. Vessels like the ones that are part of the Maritime Security Program, for instance, a program of the MARAD, the Naval Administration of the US that has an agreement with the US Department of Defense for transferring all the military equipment that is killing Palestinians in the Gaza Strip. And this is the kind of efforts that we are trying to push, that we are trying to move forward with this campaign. We need also to enhance transparency in customs and international trade to ensure that there is that all the transit control provisions are effective. Because if there is no transparency, for instance, in the manifesto of cargo of those vessels, all these provisions trying to prevent and control the transit of illegal goods, it just becomes something useless. We need to develop more transparency in order to be able to control these illegal transfers of military goods or energy that are, again, fueling this genocide. And as we speak, I think it's important to mention that there is already now another vessel carrying F-35 parts to Israel from the US. As we speak, we have Maersk Detroit, a vessel that is part of this maritime security program that is on its way to provide the genocidal regime of Israel with more weapons. It has expected to go through the port of Tanger in just 10 days, the 20th of April, and we are mobilizing groups, we are mobilizing people across the Strait of Gibraltar, in the port of Tanger, in the port of Algeciras, and also expect more mobilizations across the Mediterranean, because we know that is people's pressure, popular mobilization, what is going to move governments to impose these very much needed sanctions. Because at the end of the day, we know that all this energy is powered by greed, by fossil capitalism, and that has an end. We all know that that has an end. But our campaigns, our efforts are powered by hope of justice and liberation, and you cannot just stop that. We have the energy to stop this genocide, and we will do it collectively. Thank you very much.
Thank you, Anna, for providing this activist-oriented, I would say, presentation, overview of the activities and the details of how companies, states, insurance companies, trade unions, etc., have different responsibilities to put to boycott, I would say, or put embargo on the provision of and shipment of energy to and other, of course, weapons to Israel. In one of my articles that I wrote a few months ago, I titled the article that the World War against Palestine. So the war is not, and the war crimes are not committed only by Israel, but it's also by by other states, almost all states in the world, by being complicit or being silent or being unable to do anything or unwilling to do anything with regard to Palestine. And this brings to the issue, us to the issue of the global responsibility and the global solidarity. And here we are honored to have His Excellency Professor George Katrougalos, who is the United Nations independent expert on the promotion and the promotion of democratic and equitable international order, who is in charge of dealing with the issue of international solidarity and how other states would cooperate to end war crimes and crimes against humanity in order to respect human rights at the global level. Professor George Katrougalos is also, he's the former foreign minister of Greece and professor of international law. I think there will be so many questions will be directed to you, Professor Katrougalos. Just to mention also that I worked at the United Nations Office of the High Commissioner for Human Rights myself in Geneva, and I dealt with many cases with the special procedures. But it's interesting also to have you as a special rapporteur or independent expert on the issue of the global solidarity. So I'm looking forward to listen to your presentation. Please go ahead. You have the floor.
Thank you very much for the invitation and the good words. I have learned also a wealth of information already from all the previous speakers. I will try to present my opinion under the angle of my mandate. As you said, my mandate is democratic and equitable international order in the framework of special procedures. For those of us in the audience who do not know what the special procedures are, they are basically the linkage between the United Nations and the civil society. They are independent experts, not paid by the United Nations, that try to promote a better understanding using their expertise, but also trying to raise solidarity. The best example among us is, of course, Francesca Albanese, who is the special rapporteur on the occupied Palestinian territories. But besides the mandates who are related to a country, there are also thematic mandates. The first paradox regarding the international order today is that we have now an arsenal of legal norms much more advanced than in the past. And simultaneously, we have so many examples of lawlessness, especially by the actions of Israel, not just the genocide in Gaza, also the continuous attacks and incursions in Syria and Lebanon. But it is not only that. We have, especially with the new American administration, but even before that, behavior, especially among strong states, that might makes right. How can we explain this paradox? Everything that's happening in the international law, actually, it's a battleground between not just national conflicted interests, but also greater camps. Global North versus Global South, capital versus labor. And one of the best examples of how this, let's say, battle is taking place, not just in the interpretation, not just in the implementation of the treaties, also in their inceptions, when they are being negotiated. UNCLOS is a good example for that. The Global South countries had a majority in the United Nations discussions. And in 1982, the first draft of UNCLOS was a very, very progressive text that defined the oceans as the common heritage of humankind. Then the might entered the game. The major maritime states, United States, United Kingdom, refused to sign and ratify the treaty if there were not changes in the text. And the Global South had to make a compromise. They had to water down the concepts of especially the legal character of the oceans. Still, UNCLOS remains a very important legal treaty that reflects the change of balance of forces within the United Nations. We must have in mind that the international law is evolving. We are not now in the colonial era. Interestingly, the division between civilized and non-civilized nations, which was the bedrock of the colonial international law, survives even today, and not less, but in the statutes of the International Court of Hague. The International Court recognizes as source of law just the law of the civilized nations, as if they are uncivilized nations. That looks the connection between, let's say, the origins of the current international law. But exactly because of the rise in power of the Global South, we had, especially after the 60s, a redirection of the international law with the two covenants, which for the first time expressively recognized the right of self-determination, later the right of development, later the efforts for a new international economic order. And then we see again the paradox, new international economic order that has been proclaimed in Bandung. We had the first North-South Global Summit in Cancun in 1982. Then Reagan and Thatcher have been invited to this global summit, and we did have a new economic international order in the 80s, but it was not the one envisaged by the Global South, but a completely neoliberal one. So do not consider that the international law is, let's say, monolithic and homogeneous. However, we must try to have a holistic view of the interpretation of the legal norms. For instance, speaking about UNCLOS, we must not forget that we must interpret it in harmony with the Arms Trade Treaty, with the Genocide Convention, with the Apartheid Convention, because we must not have silos in international law. My second remark is that the opinion of the International Court of Hague regarding the illegality of the occupation per se is a watershed moment that we must try to exploit as much as possible. It is not anymore individual, let's say, behavior and acts of Israel that commit violation of the international legal order. Of course, we have crimes against humanity, we have war crimes, we have genocide, but the existence, the mere existence of the occupation is a violation of international law. And the General Assembly has convened in order to, let's say, specialize the necessity of implementation of this important decision. And in September, 18 September 2024, it has basically indicated three obligations. The first, that all states must take steps towards ceasing the importation of any products originating in the settlements, and also the immediate stop of any provision or transfer of arms, munitions, and related equipment. The second point of the General Assembly is that the states are obliged not to render aid or assistance in maintaining the situation created by Israel's illegal presence. It's what I was speaking before, not just specifically prohibited actions like sale of arms, like the energy embargo that we discussed. Anything that facilitates the perpetuation of the illegal occupation is now contrary to the international law. And the third point of the General Assembly is that the states must ensure that any impediment resulting from the illegal presence of Israel in the occupied Palestinian territories to the exercise of the Palestinian people of its right to self-determination should be brought to an end. We must not just denounce crimes. We must show what is the way out of this quagmire. And this could not be something different than a Palestinian state, a really independent and sovereign Palestinian state, exactly as it has been put out in many resolutions of the General Assembly. There was also a fourth point that the General Assembly reminded that the International Court of Justice stated that all states parts to the Fourth Geneva Convention have the obligation to ensure compliance by Israel with international humanitarian law. This is very important because we know what's happening even now in Gaza. The killing of tens of thousands of civilians, children, and basically another step towards the genocide. Because I want to respect the time limits, let me proceed to some specific remarks to UNCLOS, although that Pierre Andrea, I think, has presented brilliantly the situation, and the very, very, let's say, important opinion of ASCOMARE. ASCOMARE and all other think tanks that are acting in the direction of pro bono support of the international law is again another, let's say, manifestation of the necessary connection between civil society and international legality. Please note that, of course, we must support the people of Palestine, but by supporting the people of Palestine, we support also the necessary corpus of international law that defines the United Nations system. The questioning of this system is not just problematic for the Palestinians and the other victims of the strong states. Undermining of the international legal order is going to be a serious deterioration, basically taking back what the Global South has managed all these last decades. As also Pierre Andrea has mentioned, UNCLOS is important because of the widespread ratification is now considered customary law. Even the United States, for instance, which are not part of UNCLOS, are respecting it. The opinion made a very good, let's say, distinction between the obligations of the coastal states and the obligations of the flag states. Pierre Andrea has said all about that. We must insist, however, that the states, especially the flag states, exercise effective jurisdiction and control over vessels flying their flag. And think tanks and NGOs should try to investigate even legal remedies in European courts, maybe the Court of Hamburg, in order to put these obligations on a more visible terms. Finally, I think that the most important thing you have heard today is what Anna has said about the necessary mobilization of the civil society. Whatever we say about law, it remains on the paper. Even court decisions remain on the paper. The opinion of the International Court of Hague, it is, as I said, of primordial importance. But it could stay on the paper if we do not put it in the minds of the simple people. Ideas are becoming a material force only when they go down to the masses. It's very important, therefore, to have a solidarity among trade unions. In Piraeus, we had also a case where the trade unions of the port of Piraeus have stopped a container going back to Gaza. And having actually a more, let's say, holistic alliance between trade unions, between human rights defenders. You know, beyond the diplomacy of the states, the diplomacy of the peoples have the possibility, not in the short term, but in medium and long term, to influence also the decisions of the big states. The war of Vietnam have ended, of course, because of the heroic struggle of the Vietnamese people, but also because of the huge demonstrations in the United States and Europe. And exactly because this is a real weapon, we see now how the, let's say, the opposition of the great interests that we are facing is trying to quash these movements. In United States, above all, with all these persecutions against students, against, let's say, staff at universities, but also in Europe, with examples in Germany and the United Kingdom, showing again that we are not speaking just about Palestinians, we are speaking about our rights and freedoms. Therefore, we must defend, of course, the rights of the weaker, the rights of those who are massacred now in Gaza, and even in the West Bank, but also have in mind that it is a common struggle for all of us. Thank you very much.
Thank you for this presentation that complemented the other presentations. So thank you for everybody for sticking to the time, and also, of course, presenting excellent presentations in addition to complementing each other. Now we'll have the floor for probably 15 to 20 minutes maximum. So for those who are interested to ask questions, we have already one question regarding the mechanisms, probably human rights mechanisms and probably the law of the sea mechanisms, and specific cases that probably any of you worked with that can be like successful case. As we know, as professors of international law and as trainers in international law, I think we all face this question on the practice, how international law can be implemented. And the crisis of international law is actually now facing this question that we always receive from our students and from our audience on how international law can be implemented when it comes to specific issues relating to the responsibility of companies. For example, like a question that I can direct to Professor Katrougalos regarding the possibility of filing complaints, so-called urgent actions, to you as a special expert or a special rapporteur to deal with specific cases when international law is violated by a company, by a ship, by a vessel, and how you can probably follow up on such cases. I remember a few years ago, one of the special rapporteurs, a special rapporteur on the right of food, sent a letter to Caterpillar company that produces bulldozers, claiming and saying that the company is responsible for shipping bulldozers to Israel, whereby these bulldozers are used to destroy Palestinian agricultural fields. So maybe something similar to that can be conducted by your mandate. I don't know. It's just a question. So I'm just asking the first question in order to give others the possibility to ask other questions. You can start answering if you wish. Yeah.
Thank you. You are very right. It is important to have remedies. Otherwise, there's not law. But this is one of the main defaults of the international law, besides sanctions of the states, besides specialized cases where we have jurisdictions. Here we have, in the UNCLOS, we have a specialized court, the Court of Hamburg. It is not the same, let's say, possibilities we have to bring a case before the courts as we have with the domestic law. We must be, let's say, inventive. For instance, you may remember how the collaboration between different legal systems brought to the end of the immunity of Pinochet. Pinochet was feeling very, let's say, safe by going to the United Kingdom. But a special prosecutor in Spain connected the crimes committed during the junta in Chile with the murder and torture of Spanish citizens. Now that Netanyahu is visiting European states, whatever the governments are saying, persecutors and judiciary must have the same, let's say, courage to act as the Spanish persecutor. Regarding now the special procedures, we are basically agents of advocacy. We have participation in legal affairs, but as amici curiae in many disputes, also concerning the genocide case before the International Court, we have submitted, a lot of us, an amicus curiae supporting South Africa. But we cannot be, let's say, parts of a litigation, exactly because we must keep our independent role. We are not neutrals. We are for the victims and not for the victimizers. But we must be objective, and therefore we cannot be part of let's say, any litigation. We can support, however, as I said before, any such litigations that are brought before international courts.
Okay, thank you. There's a question to Leo regarding the responsibility of the European Union under the law of the sea. Would be any claims that can be brought against the European Union and the responsibility of certain or maybe a number of European states by who ship arms and gas and other equipments to Israel?
Thank you, Motat. I think that the short answer when it comes to the European Union directly is a negative in the sense that the European Union is a contracting party to UNCLOS since I think 1998 or 1994. So there are specific obligations which applies on the Union as a party. And they were also examined in a number of cases, in particular when it comes to fisheries. There was also an advisory opinion in 2015 of the BIICL who looked at that. The point is that the European Union has a specific obligation as a party, notably when in areas where there is exclusive competence of the Union, like in the case of fisheries. While in the specific cases under discussions, I think that could not arise, but as Motat said, I mean, I believe that in any case, the responsibility of each individual states under the relevant international instrument, including UNCLOS, and as far as I remember correctly, all the member states of the Union are contracting parties to UNCLOS, for instance. So in that case, of course, it would operate independently of what could be the responsibility of the Union as a party, I guess.
Thank you. There's a question to Anna, like a general question on certain examples and cases that you might have come across during your work in the campaign that can show some positive impact of how international law mechanisms can work in real time to prevent the transfer of weapons and oil and gas to Israel.
Thank you for that question. I think it's great to show that actually we can succeed in that. According to our experience, was not international law what created this change or what protected the human rights. It was, again, like popular pressure and the mobilization of the civil society calling on states to fulfill their own obligations. But I can give you like the example of Colombia, that it was one of the main coal exporters to Israel until last August 2024, when they issued a decree to ban all coal exports to Israel. And that set a very, very important precedent that shows that we can translate all these very good political declarations into something that can actually have an impact on the field, that can actually impact and help into protecting Palestinian rights. And that was this call to ban coal exports to Israel. It came because of the mobilization of the miners' communities, the indigenous miners' communities that were very much affected by private corporations such as Glencore that were violating their most basic human rights, and were these communities the one that were standing up for Palestine and for protecting this, that as Professor George explained before, also it's not only about Palestine, but it is also about a global crisis of democracy. So I think this is what we need to keep on pushing, to understand that we need to own, to appropriate all these systems of international law and not leave them for international courts and closed rooms, but try to take this into practice and just trying to understand that we own this, that we have the power to push our governments to impose those very much needed sanctions.
Thank you, Anna. There is a question to Irene, but it seems that she left. So I would raise this question probably for anybody of you, anyone of you who would like to answer. There's a question regarding the Houthi or Yemen attacks against ships that carrying oil and weapons to Israel. I know this question is a bit creative, I would say. So regarding the legality of targeting the ships by the Yemenis in Bab al-Mandab crossing. So I don't know if there is anybody of you who would like to touch upon this issue, the legality of the attacks against, or I would say embargo attacks or embargo of ships in Bab al-Mandab area.
I can give it a try if you want, Motats.
Please, yes.
Okay, what I think it's evident also from the findings and conclusions of the opinion is that in any case, coastal states have, as we said, certain rights and even obligations when it comes, to vessels transiting to their waters. Which means, on the one hand, that we cannot exclude the fact that certain actions could be taken in circumstances, especially to discharge the obligations of these states as coastal states. At the same time, we need to be aware of the fact that there is quite some extensive case law dealing with enforcement activities at sea, starting from the Saiga 2 cases in 1999, indicating that any kind of use of force at sea shall be subject to the three general principles of proportionality, necessity, and the need to use the kind of action which is use of force only when it's unavoidable. So I would say, looking at it from a purely, let's say, academic standpoint, that the question we should ask ourselves is if these three principles in the actions which has been taken so far have been met or not. And this is why I know that the academic, world dealing with the law of the sea is certainly divided on the topic, because on the one hand you will have, scholars saying that these actions are not proportional, are not maybe could be considered by some necessary, but not proportional and not unavoidable, at least not a last resort, let's say. While for others, indeed, the element of necessity in this case could prevail. So I think it's a very difficult questions, very difficult legal questions.
Yeah, so again, thank you very much all for these interesting presentations. What makes presentations and discussions interesting is that they create more questions than answers. So we'll keep with us all these questions that raised during these presentations. And I think these questions are not only targeted to you, but also I think to the I would say international legislators. But because I think those who created international law did not imagine when they drafted the Human Rights Conventions and the Convention on the Law of the Sea and other conventions on international humanitarian law, did not expect this scale of crimes that will be committed one day, probably in the future, after after crafting all these instruments that developed under international law. And this faces us with, I think, with a challenge as international lawyers, international legislators, international organizations, on how international law can be reformed and changed, and what are the gaps that exist in international law, and what are the new tools and mechanisms that need to be developed in the future in order for the world to be ready to face such international crisis in the future. Otherwise, unfortunately, that will create the law of the jungle at the international level, and might, for God forbid, lead us to a third world war. So, and by this remark, I would conclude my comment. But probably Brendia wants to say one last point, and I would also, of course, ask George and Anna if they want to say anything to conclude. Brendia, please.
Thank you, Motazzi. But indeed, I fully share this remark that you made, and also I would like to go back to what also Anna and George touched upon. So the importance of considering, in any case, the legal element, the legal considerations, hand in hand with the advocacy efforts and the mobilizations. I think this is really critical. The fact even of talking about this topic is essential, because it gives the possibility, as you say, Motas, to raise additional questions, or at least to create a network of people that can work together to answer some of the open questions. So for all these reasons, I think it's really critical to talk about these, and I think it's this is why thank you very much also for organizing this event, and which is for these timely discussions.
Okay, thank you. Anna, please go ahead.
Yes, just like following on your last comments, I think we do need to reform this international law system, and we need to decolonize international law as well, and to make it more democratic. I think it is not is now not conceivable to have the colonial powers sitting in the UN Security Council with a right to veto initiatives that are protecting human rights. So we need to transform this, because one of the things that I think we are all learning from the ongoing situation in Palestine is that the current system is not designed to protect life, is not designed to protect dignity or human rights, is designed to protect the interests of private corporations or other interests that are beyond what is the values that are supposed to be protected by this international law system. So I think that's a priority for all of us. And again, like keep not losing the hope. That's something that we cannot allow. So keep pushing for popular mobilization and supporting all these initiatives coming from below that will build this movement of justice that we are all seeking for. So thank you very much for organizing, and hoping to see you soon.
It's good to conclude by this positive remark. So at the end, I would again thank all the speakers for being with us this evening. It's very interesting discussion from which I learned very much. I would like also to thank the organizers, my colleague in the law of for Palestine, ASCOMARE colleagues, and our colleagues at the Independent Commission for Human Rights. I would like also to thank all those who raised questions and tried to participate in the discussion. I would like also to extend thanks and gratitude to Jurists for Palestine Forums, members of the Jurists for Palestine Forum, all those who were with us over the past 90 minutes, and all those who were following this discussion over YouTube and other platforms that broadcasted this event. I would like also to thank, last but not least, the interpreters, Amani Al-Agha and Rana Awad. And we look forward to continue this discussion, and hope to see many of you, the speakers and the audience, in other events. Thank you very much, and good evening and good night. Bye-bye.
Thank you, everyone.